Hello friends, myself Dr. Prachi Motiani, Assistant Professor, University School of Law, Gujarat University. I'm thankful to HRDC for giving me this wonderful opportunity. Today, I'm going to discuss with you the concept of law and our Indian Constitution. At the end of this session, you will come to know what is law, sources of law, why we require law, why we need Indian Constitution, framing of our Indian Constitution, the brief idea about our fundamental rights and our fundamental duties. Now, let's begin with the session. Kindly share my screen with you. Concept of law, Indian Constitution. As we know that law is a social science because law requires for the society. We cannot presume the smooth running of the society without law. No doubt, there is a different meaning of the law for the different person, such as if the law, if you will ask what is law to law students, their answer would be different. If you will ask what is law to any layman, their answer would be different. For judges, law is also different. So it depends upon the person how they will interpret the what is law. But it is necessary that for the growth and development of the nation in a smooth manner and for the development of the society, law is a basic requirement because without law, we cannot regulate the society in a smooth manner. With the help of law, new developments in the society, whenever it creates problem, which we can regulate with the help of the law. And law is required to deal with those problems. Now let's discuss what is the law. In general sense, we can say that law is a bundle of rules which we have to obey. Here, the different jurists had given the different definitions of the law. Let's see one by one. Austin says, law is the command of sovereign and it is enforceable by a sanction. Whereas Ruscopound said, law is a social institution to satisfy social wants. Here, the social engineering theory of the Ruscopounds play a significant role to discuss what is law, because law and society both are correlated. We can change the society with the help of law and we can regulate it in a smooth manner. Salmon says, law is a body of principles recognized and applied by the state in the administration of the justice. Now, what is the purpose of law? The first purpose for the law is maintenance of law and order. I can give you one simple example. If there is no law in society, then any person can do a murder, theft would be increased. Most of the crimes would be happen day by day. And if there is no law, then we cannot presume what would be the situation of the society. So ultimately, the law is required for the maintenance of the law and order in the society and for the smooth running purpose of the society. With the help of law, we can reduce the conflicts between the persons. The second purpose of law, it enables individual to have maximum freedom to assert themselves. As our Indian Constitution provides our the fundamental rights, the same way we have also fundamental duties. But with the help of law, each and every individual can get the maximum freedom and they can enjoy their life in a better manner. The third one, maximum satisfaction of the needs of the people. Law provides the equal distribution of the enjoyment of every right to each and every person. That is possible with the help, and it is directly related with the satisfaction of the people. Now, the major objects behind law. Object of law is justice. Because if we don't want justice, then there is no need of law. So the law is for the justice. Justice operates at two different levels in the country. Number one, distributive justice, which serve to secure balance among the members of a community. Whereas corrective justice serves to correct the disequilibrium created by a wrongful act. Now, kinds of law. We have municipal laws as well as the international laws. International laws are generally known as the law of nations. International law further divides in two categories: public international law and private international law. Public international law covers the body of rules governing the conduct and relations of the state with each other. Whereas private international law, it provides the rules and principles governing cases having foreign element, applies to individual and not to any state. Municipal law. Municipal law is generally known as the law of land. If we will study in detail, we will come to know that international law is a generally weak law in compared to municipal law, because municipal law applies to the particular state, whereas the international law, it's applied to any all our countries in the world. So sometimes with the development of the nations, the international law is keep changing. So it is difficult to cope up for the international law with the all the development, because it is a keep changing law. Whereas the municipal law, it depends upon the state and it's related to the law of the land. Now look at here, municipal law, it's also public law, which determines and regulates the organization and functioning of the state and determines the relation of the state with its subject. Whereas private law regulates and governs the relation of citizen with another. Public law. In the category of the public law, the constitutional law, administrative law, and criminal law comes. Constitutional law includes all rules which directly and indirectly affect the distribution or exercise of sovereign power of the state. Constitution is the basic document of the country. Administrative law. Whereas administrative law determines the organizations, their powers and duties and administrative authorities. And criminal laws defines offenses and prescribe punishment for them whenever any crimes occur in the society. So criminal law play a significant role for the punishments for the crime. Whereas private law also include personal laws, laws of property, law of obligation, general laws, ordinary law of the land, and special law, legal rules which are special, exceptional in their nature. Now, kinds of special law. Kinds of special law covers the local law, which belongs to the law of a particular locality. Whereas foreign law, law of a foreign country. Marital law applicable to soldiers as well as the civilian in times of war. Marital law further includes the Special Marriage Act, Hindu Marriage Act, the other related marriage acts. The military law applicable to soldiers alone. Now let's discuss about the sources of law. Sources of law. The first source of the law is legislation, precedent, customary law, and conventional law. Now, let's discuss about the legislation. Legislation, making of law by the formal express declaration of new rules by some authority in the body politic which is recognized as adequate for that purpose. Means the making of law or declaration of legal rules by competent authority. Legislation are supreme legislation proceeds from the sovereign power in the state. Subordinate legislation proceed from any authority other than the sovereign power control over delegated legislation. Now, we will discuss about the precedent. Precedent means making of law by the recognition and application of new rules by courts themselves in the administration of the justice. Judicial decision to which authority has been attached. The reason why a precedent is recognized is that a judicial decision is presumed to be correct. Under this rule, a principle of law which has become settled by a series of decisions is generally binding on courts and should be followed in similar cases. So due to the precedent is the one of the source of the law, and the doctrine has been recognized by the Constitution of India. Apart from this, the Supreme Court is free to depart from its previous decision if valid reason exists for doing so. Now, the next source, the customary law. Customary laws constituted by customs which fulfill the requirements laid down by law as the condition for their recognition as obligatory rules of conduct. Uniformity of conduct of all persons under like circumstances, which depends upon the circumstances. Now, the next about the customary law, it is observed course of conduct. It is rule which has existed from time immemorial and obtained the force of law in particular locality. Now, the next source, conventional law. Conventional law, it is the which is constituted by agreement having the force of special law inter partes. So these are the basic sources of law. Apart from conventions, treaties, also there are part of the law. Now let's discuss substantive and procedural law. Substantive law means those which define right, duties, and liabilities. Substantive criminal law is contained in the Indian Penal Code and various special and local laws. Substantive civil law is contained in acts like Indian Contract Act, Hindu Marriage Act, Transfer of Property Act, etc. Procedural law, those which define the pleading and procedure by which substantive law are applied in practice, which covers the CPC, the Civil Procedure Code, and Indian Evidence Act are the examples of the procedural laws. Now let's discuss what is Constitution. As we know that the Constitution is a basic document of the any country. In India, whatever laws has enacted, that laws has enacted in the light of the constitutions. So here need to understand what is Constitution, why we need Constitution. Some rules that are made by the legislature for their own country are called law. As we know that we need law in society, so our society can regulate and work properly, and the equal distribution of the any natural resources and wealth has been distributed amongst the people of the country. They are designed to protect us and our property and to ensure that everyone in society behaves the way that the community expects them to. Law generally tells us what to expect as the consequences of our actions. Laws have been the glue that has kept society together. So ultimately, law requires for the society, and law is a tool of social change. Now, if we look over the constitution, so we can say that constitution is a supreme law of the land. All other law have confirmed the constitution. The constitution contains law concerning the government and its relation with the people. Our Indian constitution is concerned with two main aspects. Number one, the relation between the different levels of the government, and number two, between the government and the citizens. Role of constitution in relationship between government and its people. Here you can see that constitution is for the government and the between the government and the people. Here legislative that makes the law, whereas judiciary interprets the law and executive enforce the law in the society. So there are the three-tier system for the law which has given by our Indian constitution: legislature, judiciary and executive, which makes law, judiciary interprets the law and executive enforce the law. Need of constitution. Why we need constitution? Now let's discuss why we need constitution. We need a constitution to govern a country properly. Without law, we cannot govern our society in a proper manner, and constitution provides the rules and regulation how the society can be governed properly. The another requirements for the constitution is the constitution defines the nature of political system of the country, how the political system would be there in any republic country like India. Sometimes we feel strongly about an issue that might go against our larger interests. In that situation, the constitution helps us guard against that particular situation which can harm to the society. And apart from this, it performs some functions. Now let's see which functions the constitution performs. The number one function of the constitution is to provide a set of basic rules that follow for minimal coordination amongst the members of the society. The second function of the constitution is to specify who has the power to make decision in the society. It decides how the government will be constituted. The third function is to set some limits on what a government can impose on its citizens. These limits are fundamental in sense the government may ever trespass them. And the fourth function is to enable the government to fulfill the separation of society and create condition for a just society. A just society is a basic need of any country. Now let's discuss the framing of Constitution of India. The Constitution Assembly of India was elected to write the Constitution of India. Following India's independence from Great Britain, Its members serve as the nation's first parliament. The body was formed in 1946 for the purpose of making independent India's constitution. The assembly passed a resolution in the year 1947, January, defining the objectives of the constitution. The number one objective of the constitution is to set up a union of Indian, sorry, to set up a union of India comprising British India and the Princely states. The another objective was to set up a federal form of government with separate state and central governments. The third one, to set up a democracy in the which all power is derived from the people. As we know that India is a democratic country. The fourth objective behind the constitution was to protect the integrity of India and her sovereign right over land, sea, and air. The fifth one, to help India attain its rightful place in the world and work for peace and welfare of all mankind. Our Indian constitution has borrowed some features from the constitutions of the other countries. As we can say that our Indian constitution is a mixture of the many other countries' constitution. We have taken the good things from the all the world's constitution. Our Indian constitution is a written document. So now let's discuss which features we have borrowed from the other countries' constitution. From UK, we have borrowed the nominal head president, cabinet system of minister, post of PM, parliamentary types of government, lower house more powerful, council of ministers responsible to lower house, provision of speakers in Lok Sabha. Whereas from USA, we have adopted the basic thing that the document, the constitution, it must be in a written form. So the written constitution, appointment of vice president, fundamental rights, Supreme Court, head of the state known as the president, provision of states, and judicial reviews. These features we have taken from the constitution of the USA. From Australia, we have taken the concurrent list, center-state relationship, language of the preamble. From USSR, we have taken the fundamental duties and 5 years plans. For Germany, we have adopted emergency powers. And from Japan, we have adopted law in which the Supreme Court functions. The preamble. This is the preamble of our Indian Constitution. The preamble of our Indian Constitution reflects the basic ideology of our Indian Constitution. It provides the reflection of the Constitution, how the Constitution should be. See, this is the beauty of our Constitution, that in the preamble, certain words has written in the capital letters, which reflects the how our country is. The sovereign, socialist, secular, democratic, and republic. Now let's discuss the purpose of having preamble in the constitution. The preamble to our constitution serves basically two purposes. The number one, it indicates the source from which the constitution derives its authority. Whereas the another one, it also states the object which the constitution seeks to establish and promote. The preamble seeks to establish what Mahatma Gandhi described as the India of my dream, an India in which the poorest shall feel it is their country and whose making they have an effective voice. An India in which all communities shall live a perfect harmony. There can be no room in such an India for the cause of unsociability or the curse of intoxicating drinks and drugs. And women can enjoy the same right which men has. So the right to equality has also taken the biggest role to incorporate the Indian Constitution. Now let's discuss what is Indian Constitution. The Constitution of India follows the federal system. Our Indian Constitution is the quasi-federal constitution. If we say in the general sense, the Constitution of India is considered to be the supreme law of the country, as it put forth the framework of the fundamental political principles, which declares that India is a sovereign, socialist, democratic, and republic country. The Indian Constitution shows the federal as well as the unitary system of the country. Now here let's discuss what is the federal system. The federal system means the powers are divided and shared between the state as well as the central governments. Whereas the union system provides the power concentration in central government with weak state government. Both features can be listed like federal features. If we look the federal features, these are supremacy of the constitution. The another one, division of power between the union and the state, which is known as a union means central government. And the third one, the existence of an independent judiciary in the Indian Constitution. Now, let's discuss the unitary features. The single citizenship. The single citizenship, it is the one of the unitary features. Apart from this, power of union to override on the state matters. The third one, during emergency, the system become virtually unitary. And the changes in the names and the boundaries of the state by the parliaments again comes under the unitary system. Then integrated judiciary system. Center appoints the governors. Dependence of state on the center for economic assistance of the branch. These are the some unitary system. Here you can see the structure of our Indian Constitution. Our Indian Constitutions comprise the fundamental rights, directive principles of the state policy, fundamental duties. Our Constitution begins from the preambles. Then after the enactment of the Constitution, numbers of amendments has taken place in our Constitution to serve in a betterment for the society. Indian Constitution also has certain schedules and appendices. If we look the fundamental rights, what is right? Here we need to understand the meaning of the right and which kind of rights are there. Rights mean the things which any person can enjoy without the interference of any other person. The person has to enjoy certain things which is generally known as a right. Rights are fundamental rights, constitutional rights, and human rights. First, we will discuss what is fundamental rights. Fundamental rights are given to any citizens from their country. Depends upon the birth of that citizen, which has given from the Constitution. It varies from countries to country. Whereas constitution rights, it's also given from the constitution, but it doesn't have the enforceability, whereas the fundamental rights has the enforceability. If there is any violation of your fundamental rights, then as per the Indian constitution, we have the constitutional remedies under Article 32 and under Article 226. Under Article 32, for the violation of the fundamental rights, we can directly approach to the Supreme Court, whereas under Article 226, any citizen for the violation of the fundamental rights can approach to High Court. Whereas constitution right, for the violation of the constitutional rights, since we have discussed, there is no enforceability, so there is no remedy for that. Now, let me give you the some idea about the human rights. Human rights are the rights which are the universal rights, which is given to the all person in a equal sense, without any discrimination of their caste, color, birth, religion, and any other discrimination. It has given to the all persons who has taken the birth, and it would be the same for the all person which has received by the any citizen or any person by the birth. Whereas fundamental rights, it depends upon the country and it has given from their constitution. Now, in our Indian constitution, fundamental rights begin from the Article 12 to Article 35, which has given under Part 3 of the Indian constitution. The basic fundamental rights divides under 6 categories, which are the right to equality, which is given in our Indian constitution from Article 14 to Article 18. Article 12 speaks about the states. What is states? Which state comprise? Which things state comprise? Now, the second, basic fundamental rights, right to freedom, which is given under Article 19 to Article 22. Article right against exploitation, the another one, which is given Article 23 to Article 24. Whereas Article 25 to Article 28 of our Indian Constitution provides the right to freedom of religion and cultural and education rights given under Article 29 and 30, whereas the right to constitutional remedies, as we have discussed, given under Article 32, where any person can approach to directly Supreme Court for the violation of their fundamental rights. Fundamental duties. As we have the fundamental rights, so the same thing, once we have right, so once we have certain things to obey for our country, which is known as the fundamental duties. These duties has inserted in our constitution by an amendment. Our original constitution did not have fundamental duties, but after an amendment, these duties has inserted in our constitution as a part 4A. Here A stands for the amendment, which is given under Article 51 by adding clause A. There initially there were 10 duties, but after again by an amendment, the 11th duties were inserted in our constitution. Rights and duties both are correlated. Once we have right to enjoy anything, the same way we have certain duties to perform for our country. Rights and duties both are like two sides of the coin. Here you can see the fundamental duties which every citizen of the country has to obey, to abide by the constitution, to uphold and protect the sovereignty, unity and integrity of India, to cherish and follow the noble ideas which inspired our national struggle for freedom, to defend the country and render national services whenever called upon to do so, to promote harmony and the spirit of common brotherhood, to value and preserve the rich heritage of our composite culture, to protect and improve the national environment, to develop the scientific temper, humanism, and the spirit of inquiry and reform, to safeguard public property, to abjure violence, to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rise to higher levels of endeavor and achievements. And the last fundamental duties which has inserted by an amendment, which is 11th duty, is who is a parent or guardian to provide opportunities for education to his child, or as the case may be, born between the age of 6 and 14 years. Simultaneously, along with this fundamental duty, the Article 21A also inserted right to education under Article 21, which is directly correlated with the right to life. Because without education, we cannot presume the any life, any person's life, which they can enjoy in a good manner. So education and the right to life both are interconnected. Due to this reason, by an amendment, the fundamental part 3 under Article 21, the Article 21A right to education also inserted, and this fundamental duties has also incorporated under the list of the fundamental duties. For the enforcement of this fundamental duties, we have certain acts also. Now, the part 4, it also covers the directive principles, which are article from 36 to Article 51. It provides the social and economic base of genuine democracy. The classification of these are as follow. The number one, it is based on the socio-economic principles. Second one, liberal principles. It also covers the Gandhian thoughts and international principles. Here, apart from this, we have the Constitution of India and the government. As we have discussed, there are 3-tier system: legislative, judiciary, and executive. Under the legislative, the Parliament of India comes, their houses which enact the law. Judiciary, again we have 3-tier system: lower courts, high court, and Supreme Court. Supreme Court is the Supreme Court of the country, which decision, whose Supreme Court's decision would be binding to every citizen. And the last one, executive. With the executive covers the President of India, Vice President, Cabinet, executive departments, and agency. So this was the basic idea about our Indian Constitution. As we know that law is a tool of social change. Without law, we cannot regulate the society in a smooth manner. And Constitution help us to govern the society by giving an idea the how we can regulate the society. And as we know that our Indian Constitution is a quasi-federal constitution, and the democracy, sovereignty, republic, freedom of religions are the basic essence of our Indian Constitution. We have certain fundamental rights. Simultaneously, we have also fundamental duties to perform. At the last, I can say only one thing: law alone cannot regulate all things. For the regulation of the smooth manner of the society, the cooperation of the citizens are also needed. These are the references. I hope you understand the concept of the law and the basic ideas about our constitution. Thank you so much.